Welcome to the Hill and Ponton podcast, and we're lucky to have Kerry Baker with us again today. Hey, Kerry, how are you?
Hello, Carol. How you doing? I'm doing pretty good.
Good, good. I was telling Kerry the leaves are changing, and I'm ready for the fall and the winter. How about you, Kerry?
Oh yeah.
Oh yeah.
Well, I don't know about winter, fall. I'm just going to play with fall here in Tennessee.
After this summer, I'll take either one. So
yeah.
I want to say hi to Radio Killer. He's always there. We really appreciate it. Hope you have a good day. We're going to pretty much answer questions today. So we're going to try to run through and answer all the questions that you have. And our first one is from Mad. Is it error for the regional office not to infer unemployability when rating decision brings the vet's rating to a combined 90% and more than one DBQ mentions that their conditions impact the ability to work? If so, higher level review or what?
You want me to address that, Carol? Okay. Well, the main question there is it error for the RO not to do that, and that's a debatable subject. That's been debated on and on and on. Now, if you've actually got evidence of a condition impacting your ability to work, does that mean you're not working? Because if it's impacting your ability to work, but yet you are gainfully employed, then no, I would say taking a strict constructive approach that's not an error because you're working. Mm-hmm. If you're not working, that's when it really becomes debatable. Technically speaking, VA is supposed to consider TDIU when the record raises it. Well, that's the question. When does the record raise it? And it's not always cut and dry. But if you're rated 90% and you're unemployed and there's indication somewhere that the service-connected conditions render you unemployed, then I would say, yes, VA has to consider it. Now, is it the kind of error that if you find 5 years later and it's not on appeal, can get you retroactive benefits? That one's hit and miss. We try it. I think it's safe to say, Kerry, you tell me if you try it, but
I try it all the time, and you're right. Sometimes they will, sometimes they won't, but I keep appealing it.
Yeah. So
I say it was their duty to send an 8940 to the veteran, and they failed in their duty. But I think, do I see them infer this? No. You have to go ahead and file. They're not going to do it. So you need to file an 8940. And I think I'd probably do that rather than an HLR. Wouldn't you, Kerry?
Yeah, I do. I would just do the 8940, file for the TDIU, see if we get it.
Yeah.
See what effective date they give it. Because, you might get it on that first try. You might give the right effective date. They might not. If they give it, then you're only arguing an effective date. That's how I would do it. Now, one thing that I see a lot, and I know the vets out there who probably don't get a copy of the code sheet, you probably don't see this. But one way raters try to get out of this is they'll put a block on the code sheet. I call it the little box of tricks. Because sometimes you find good things in this little text box on the code sheet, and it won't say to the vet, it'll just say to somebody looking at the file that they did not raise TDIU because they essentially looked at the record and didn't see enough that would cause them to raise it. So in other words, they're CY, they're covering their ass. And so, is that debatable? It probably is, but it does tell you that the rater thought about TDIU and then expressly put something on the code sheet that says, no, we're not going to consider it because we don't see it grantable in the record, something like that. Now, here's the thing, here's the rub, and I kind of agree with this one. VA is not supposed to raise things or infer them and then address them on a rating decision just to deny them. Right. And so they would not raise it just because you're 90% unemployed if the result is going to be a denial.
Right.
And that's, so they get away with saying that sometimes. Well, we looked at it and we decided, no, we weren't going to raise it because we couldn't grant it. Is that legal? It's a pickle. It does show that they didn't forget it.
Right.
But beyond that, it's case by case, I think, at that point, really.
Yeah, but I think we've had a lot of luck by saying the older cases, going back and saying that it was clear that the veteran wasn't working. They had a 70% or more rating, or 60%, depending on what it was. And they failed in their duty to assist. So I definitely would, like Kerry said, I think I'd file the 8940, get that claim going, and then worry about the onset date. Peter Barrett.
That's a good question.
After the PACT Act passed, the VA sent me to get a pulmonary function test. I'd claimed bronchitis in the past, but was denied. Is this a good sign? Looks like it to me. How about you?
Yeah, I'd say it's a good sign, but now I would also, it makes me wonder if you didn't file for, or you didn't refile for the disability, VA is not on the hook to go find these cases and develop them on their own. So are you sure you got a pulmonary function test because of that previous claim? Or did you file a new claim? Or is it just for treatment purposes?
And so to be safe, make sure you file, right?
Yeah. Don't assume that they're doing that just because they had previously denied it and the PACT Act now makes it presumptive, because the PACT Act requires you to come in and file a new claim. They don't have to re-adjudicate it on their own. And they're not starting those cases until January.
Right. So
I would take it as a good sign, but I wouldn't take it as a sign they're reconsidering your case. You need to find out for sure. Because
exactly.
It surprised me that they're not.
How long is too long for a higher level review? It's been a year, 4 months, and 3 months since the C&P exam. I would definitely write a letter. What is going on? That's pretty long.
That's okay. Too long.
Yeah. I am scheduled for a C&P exam for 12 conditions for the same appointment. Is this normal? When I called VES, they said I would have a general medical exam. What should I expect? They're basically going to go over everything. And I don't think this is going to be the way they do this. It's kind of a general exam, but they don't get, and then if they find like a back problem, then I think they would send you for an orthopedic exam just for that. Don't you think that's usually what you see, Kerry?
Yeah.
Okay. By the way, Combat Craig is here with us today. I want to say hi to Combat Craig. Hope you're having a good day. If anybody doesn't know who he is, he has a podcast and he is really good. Okay, Joe Stovall, I was wondering if you have seen unemployability with several bilateral carpal surgeries in service and secondary depression. Yes, I think you can get that with both of us, just depending on how bad they are. Vicki Mitchell, my husband passed recently from lung cancer, contributing factor hypertension. My husband was on a burn pit registry and has had his interview. Should I file a claim for PACT Act? Kerry?
Can you read that again? I'm sorry.
Okay. Her husband recently passed from lung cancer. The contributing factor was hypertension. Her husband was on burn pit registry and has had his interview. Should she file a claim for the PACT Act?
Absolutely.
Absolutely. If you're 100% permanent and total with SMCS, are you allowed to work, or are there any restrictions?
If you have a scheduler 100% rating and it's not based on total disability, based on individual unemployability or TDIU, then yes, you are entitled, you are allowed to work. As long as you're not getting 100% based on unemployability. Beyond that, you could be R1. If you could manage to work, you're allowed to. I don't know anybody's rated R1 that could work, but yeah, you're allowed to work in that scenario.
Here's one from Danny Gators, and Matt. Too bad Matt's not here since he is a raving Gator fan. Just started my fight with the VA. Finished all my compensation and pension exams. Most were only 10 to 15 minutes, but my PTSD one went on for 2 hours. Oops. Danny, I'm not seeing the question. Let's go on to Steve Bennett, and maybe that will pick up later. I attended one C&P exam last week for five items. all respiratory and central nervous systems. The doctor talked to me for 30 minutes and asked me to raise my legs and arms. Is that normal? What is that?
We're not healthcare experts, and we don't know what kind of exam they were technically doing. I don't know. It doesn't sound normal if they're examining your respiratory condition. But I can't say that for sure.
Yeah, we need to know what it was for, and also get a copy of the C&P exam, and that will tell you what the doctor said he did or she did, and then you'll know pretty much whether that was right or not.
Yeah, and they could have been directed to fill out a particular DBQ that had something on it that might ask you to do that.
Right.
It may or may not have been pertinent to the case. They're going to go down the list of that DBQ and do whatever it says.
Right.
So, if they're doing multiple DBQs, then yeah, you could expect something like that, I would think.
And sometimes they're only asked to do one thing, and they're not asked to do a thorough exam. So it's really no way to say. Is there a link between tinnitus, the ring in your ears, and migraines with depression and anxiety? How would you file this if you haven't been out of service for over a year, primary or secondary? Well, if you have these conditions and it's within a year of discharge and it's to a 10% rating level, I'd file it as primary, wouldn't you?
Yeah, if you haven't been out of service but less than a year and you've got those conditions, I would file them as directly related to the military service. And then in the alternative, secondary to and or as aggravated by the tinnitus, but that's going to be a tough claim.
Yeah.
To the original question, can it be a claim? Yes, it can. But you're going to have to show you have a pretty significant case of tinnitus for them to go linking a mental health condition and migraines to it. I would not, here's the thing, migraines is technically under the nervous system, all right, diagnostic code 8100. That is technically considered or it can be, certainly make the argument, an organic disease of the nervous system. And that falls under 3.309A, that if you get diagnosed within a year of service, it's automatically presumptive within a year of service. Don't confuse that with everything being presumptive if you get it within a year of service. But migraines are, okay, because they're not per se, but under the central nervous system, organic disease of central nervous system, just like tinnitus, that falls under that particular category. The mental health wouldn't count unless it's a psychosis. If it's a psychosis within a year, then you don't need to claim either one of those related to tinnitus. But you could always throw the tinnitus in there as an alternative theory.
So if you can get it service connected directly from service, that's your best bet. If you can't, then you go to the secondary. But I have to tell you, Kerry, last week, I had a veteran that I had done a mental health claim for, service connected directly, and we was totally denied. And then I filed a claim for a mental health secondary to tinnitus, and I got a favorable at 70% right away. That's the thing about the VA. You never know what you're going to get. And so you need to allege everything you can. I mean, I was totally shocked, but so you want to try whatever you got. We had skipped this. Ryan Koch. I was rated at 0% for sleep apnea in 2004. And not until I went to a non-VA sleep study in 2019 did I receive my 50%. Can I file for back pay?
Maybe. If the record you said 2004, is that what it was? If the record then showed that you were on a CPAP, then possibly that might be what's called you can't just file for back pay. That's a little myth. You can't just come out of the blue and go, I'm filing a claim for back pay or claim for an earlier effective date. An earlier effective date by itself is not a standing claim. It has to be tied to something there. In this case, it would have to be tied to clear and unmistakable error. So you would have to show that 2004 decision was product of clear and unmistakable error. If you could show that, then they have to correct it as if the error never took place. as they do with any clear and unmistakable error. In order to show that, you have to show that you were on a CPAP at the time and that they somehow missed it. If you were not prescribed a CPAP, then I don't think you're going to get the 50% back there. What do you think, Carol?
No, I don't.
Yeah.
And this right now, also, this brings up what Kerry and I were talking about before we started. What we do each week is try to tell you the things that we see veterans are really having a problem with. And one of the things that is driving me crazy and driving veterans crazy is knowing what filing a claim means. So I have seen veterans and I'm talking years now, since it started back in 2015. Veterans will try to file a claim and the VA will say, we see that you tried to file a claim for whatever, but you didn't file on the correct form. And so please file on the correct form. Well, the problem is our veterans don't know what the correct form is. Before all of this changed, before the AMA, the correct form for a new claim was a 526, VA 21/526, and everybody knew that. But now the claim has to be on either that form or an VA 210995. So the 0995 is called a supplemental claim. And the other we sort of refer to as an initial claim. So what the VA is saying to you, if you filed a 526 and they're saying it's wrong, then you need to file an 0995. If you filed an 0995 and they're saying it's wrong, file a 526. What our veterans are trying to do is they keep filing the same form over and over again. And they're just losing all of these past due benefits. So the initial claim, when you've never filed a claim for this before, is 526. But say you've been denied in the past, then you want to file an 0995. So I think we're going to put these up on our website so you can see the two different forms. Any advice you'd give them, Kerry, about that?
Yeah, there's a rub.
Yeah.
As there is with most things. So what Carol said is the best way to look at that. Never claimed before, 526. Denied in the past, 0995. Now, these aren't the only two forms now that you could end up filing incorrectly. Well, let's say it's an increased rating. All right, say you've got a rating at 0% for whatever, and you got that 5 years ago, and you want to file for an increased rating. That is not a supplemental claim. That is a 526. All right. That only come about since the AMA, okay, of being forced to file an increased rating on a 526. There were other forms, even if they were shortened versions of the 526, you could do that on prior. But if it's a previous denial, it's a supplemental claim form. If it's an increased rating where the rating was less than a year ago, it's a 526. If it's that same rating but less than a year ago, what did I say? If it's more,
I think it's backwards.
Yeah, if more than a year ago, it's a 526. Less than a year ago, then you want to use a supplemental claim form. And that sounds easy enough for us to say, but we see this all. Carol's right. We see this all the time. VA, if you're listening, you should have been ashamed of yourselves for creating so many forms to do some simple things in VA and thinking everyone was going to understand it, because your own employees don't, veterans don't, and a lot of advocates don't. And so, yeah, the forms issue is a mess. It's causing a lot of chaos, and it's costing a lot of veterans benefits. So you get a little letter that says, we need forms filed, we need claims filed on these kind of forms. We are not taking further action on your case until you give us the right form. That's about all it will tell you in a nutshell. It will not tell you what you did wrong. Well, at least not the ones we see. It doesn't tell us that.
No, it doesn't.
That means they stopped your claim. They're not prosecuting it anymore. And you don't have a claim, and you might think you do. And that's just, it's just bad service from VA, and it's complicated the hell out of what was almost an understandable process.
And what Kerry said is right. That's the way to do it. Well, even the VA doesn't know how to do it. They are often telling us to file the wrong form, that we filed the wrong form when we know we filed the right form. But my point is, get them to process your claim. So if they want a 526 and you know it should have been an 0995, just give them a 526. And that's why if you know you filed one form, 526, and now they want another form, just file an 0995 if you're filing claims, okay? Yeah. That way, no matter what, you filed both of them for them.
And you could very easily have to file 3 or more forms. You know, if you got multiple issues on a decision, or there's multiple decisions, and some are within a year, some are not, and say you want to raise TDIU, you could end up having to file a 526, a supplemental claim form, a higher level review form if you have an issue on one that's within a year you want to appeal, and possibly an 8940 if you want to file for TDIU. That is ridiculous to have to file potentially 4 forms to get all that stuff going off of 1 or 2 rating decisions. But that's, that's the way it is now, unfortunately.
And Kerry, I had a guy come to me that had been trying to file the right form, but he kept filing the same form over and over for 5 years. And he's lost those benefits because he didn't have a pending claim. And that's why I'm saying this is a real mess. And if you filed one, file the other. If you don't know what to do, get somebody to help you. Okay. And like you said, a lot of times, a lot of the VSOs and other people don't know what to do. So please get somebody who knows what they're doing.
Of course, we know what the VSOs are doing. They're following 10182 straight to the board and asking for hearings and everything.
Yeah. Yes. Please don't do that. Okay. EOE. Does hypertension fall under the PACT Act? And if so, when does it start? Kerry? It's a good question.
It falls under the PACT Act if you were exposed to herbicides. And when it starts is probably up for debate. Yeah. We think it's going to start when they start adjudicating the rest of these claims in January of 2023. But it's not clear. They've sent out a letter to the field offices, and by the time we got to the end of that letter, we weren't 100% sure what they were saying. And the letter was meant to tell them that they're going to waive this delayed, staggered, process of effectuating these claims. And I'm not sure if it said that at the end of it, or if it only said certain people will get the claims done immediately based on good cause. You read it, right, Carol? Did you see that?
I read it. And the problem is we were told, the law said initially that they were going to stagger when these claims came into effect. And then we were told, President Biden said he wanted them started immediately. And then we were told by the VA they would be started immediately. And then we get this, whatever you want to call it, and it doesn't look like they're starting it immediately. It looks like they're going right back to what the law initially said. So no one's clear, and until they start evaluating these cases, I don't think any of us will know for sure.
Yeah.
Angelo Guadaquive. I attended my first C&P exam for PTSD and TDIU. I'm scheduled for another C&P for the same claim. Is this normal? What should people expect when submitting similar claims? Kerry?
The first one, they could have looked at the first one and thought they saw something that made the exam inadequate, and they're requesting another one. We see that all the time. Am I interpreting that right, Carol? She had an exam, and then out of the blue, she had another one before they rated the case. That would be my guess, is they felt something on that exam was not adequate for rating purposes. Either the examiner forgot something, didn't fill it out all the way. I'm guessing there, but we see that all the time, where they have to call the person back in for another exam.
I see that a lot with the PTSD and the TBI, because remember, if they're overlapping and you can't tell the difference between the symptoms, then they have to give them all one rating. If they're separate symptoms for TBI from PTSD, then both of them get rated. And I see the VA trying very hard not to give separate ratings. Sometimes, and so you're sending, a lot of times they'll send a letter back saying, can these be rated separately? Can you distinguish between the symptoms? The problem is you really don't know what they're asking for. The examiner clearly wanted something that they didn't have initially. Fred, I have sleep apnea studies done in 2014. Am I wasting my time? I don't think so. If you want to file a claim, you still have sleep apnea. Do you see a problem with that, Kerry?
I don't think there's enough evidence there or information there to know if you're wasting your time. So I'd have to say no. I mean, if you got it and there's a reason to file for it, you're probably not wasting your time.
Yeah. Here's a question from All American Veteran AAV. Veterans should just file both the 526 and the 00995 and let the VA figure it out. Sometimes I'm tempted to do that.
Yeah, I mean, I can see somebody. I've done that before when not exactly like that, but when there's been very strange scenarios in cases, and it looks like the VA might not even know.
Exactly.
Is this legacy or is this AMA? And I've filed both the Form 9s and the AMA paperwork and said, all right, one way or another, you're not shooting down this appeal.
Exactly. Okay, Bossman 562. Can I apply for migraines secondary to sleep apnea? Absolutely, and I've seen them grant that. Green Thumb. I just filed a claim for accruing acute bronchitis due to burn pits. I already had my general exam and pulmonary function test done. My question is, how effective are buddy statements?
It depends on for what purpose. It sounds like it's for.
Oh, wait a minute. I'm sorry. It goes on. My wife wrote a buddy statement as well as 2 former coworkers. I saved all the medical documentation from when this started. I'm currently at 30% for knee and wrist issues and hoping for a nice increase with this new claim. I plan on doing a secondary claim once I get the results of my current claim. So it's like you said, I guess it depends on what the buddy statements are for. It doesn't really say.
Yeah, I mean, if you've got the condition and you fall under the PACT Act, you shouldn't need those buddy statements to get service connection. It should be a presumptive. You should get service connection for that. And let's just say, going off that assumption, can they help for service connection? Sure, but you don't really need it with the PACT Act. So if the buddy statements are for rating purposes,
right,
it just depends on what you're having them write about. If you're having them write about something that requires medical knowledge in order to come to a conclusion about something, then you might be crossing the Colvin line and getting into the point where you're basically trying to come to your own medical conclusion. And if the people writing those statements are laymen under the law as far as medical purposes go, and they probably are, the VA is going to say, no, that has no probative value. But if they're talking about something they're capable of observing and relaying, like, I watched so-and-so go up a flight of steps, and they could only make it halfway up the flight of steps because they went into respiratory failure, or they got so out of breath that they could not continue that. You don't need to be a medical expert in order to witness that and talk about it. So something like, and that could help with rating. Or my husband's had to quit work or has to take work half-time instead of full-time because he has trouble breathing. Things like that are capable of lay observation, and you as a layman are legally competent to say that. You're not legally competent to say it's the bronchitis that's causing my husband to go into respiratory failure.
Right.
It might be.
But we're back to presumptive, not needing a nexus. So remember, this is a new concept you have to understand. If the VA is saying we are presuming that this is service connected, then that's an issue you don't need to worry about. Forget about it. So it's going to be service connected, then start working on the rating. So remember, you've got to remember when you need to have a nexus, when you need to prove that it's connected, and when you don't. And when the VA grants you presumptive, like they have in this PACT Act for bronchitis, you're good. Don't worry about that. Extreme. My telehealth C&P exam was scheduled for 105 minutes. It lasted about 30. I didn't feel like the guy cared. He kept looking off to the right and left. He was in his room. What you want to do is get a copy of the C&P exam and then give your impression of what kind of evaluation it was. And if you don't think it was a good one, ask for another one, okay? Michael Goins. I filed for lymphoma on December 15th, 2020. Gulf War vet. 12,000 records given to the C&P examination 2 days prior to the DBQ for IBS, secondary to lymphoma. I was not rated for either. Reviewed 5 other conditions over 2 hours. I don't see a question there. Okay, Fred, I'm 75 and have 60% for heart and 20% for diabetes. Can I get IU? Kerry?
Yeah. I mean, you're 60 for a heart, you just have to have 60 for a single disability, or a 70 with one of them being at 40 if it's a combined rating. So you meet the scheduler criteria, it sounds like. The next question is do those disabilities cause you to be unemployed? That's going to be a case-by-case basis. But yeah, you can win that case depending on the circumstances of, stuff that
And remember, Fred, you're 75, but the VA doesn't consider age.
Right.
Although I think they really do. I mean, they're not supposed to, but if you have a 30-year-old with the same conditions applying as a 75-year-old, I think it's much easier to win unemployability. But technically, they're not supposed to consider that. Roland Moreno, I have a flat foot. Should I claim secondary to lower back of 20% and have rating for lower back radiculopathy? So I'm not sure if are you claiming the flat foot as secondary to your back? If so, I don't think that necessarily would work, but the other way around, if you're claiming low back, secondary to your flat foot, I think that would work. And your back, definitely, you should have radiculopathy awarded with that. Green Thumb was just saying it was for observation purposes, so maybe that is just for the rating that we're talking about. Can a VA rater deny a claim when the medical opinion sides with the veteran? Both my DBQ and VA C&P exam provider agreed my claim is service-connected, but the rater denied my claim. How?
Well, we see things like this all the time.
All the time.
But odds are you've got a very good appeal. I mean, you can't, it's hard to put that into an answer that covers everyone, because there are some things that you're going to come out with a favorable exam and still get a denial. And a lot of times that's going to be an unlawful denial. Sometimes it's still an accurate denial. It just depends on the circumstances of the case and what it is you're asking them to service connect. Most of the time, though, I would say vast majority of the time, if you've got that scenario, then they incorrectly denied your case and you need to appeal it. I mean, it's that simple.
Kerry, I can tell you where I see it all the time, and that's with PTSD claims. I had one yesterday, and the examiner said clearly it's service-connected, related to his stressors, and the rater said you haven't proved the stressor, so it's not service-connected. They could have looked at that as an acquired psychiatric disorder or something else, but they don't. They just deny it. So you need to try to figure out. That's why you always want to get a copy of that of the examinations, the compensation and pension exams, and see what everybody's really talking about. Isn't it illegal, though, for an examiner to substitute a rater, to substitute his opinion for a medical doctor?
Yeah, same thing we were talking about earlier. That's a Colvin violation. You and I can't do it, neither can the rater.
Right.
Neither can the Board of Veterans Appeals. We're all laymen under the law when it comes to being medical experts, unless we're an actual medical expert.
Okay, now this is back to, let me see if I can get all of this up here. It says, rated for a service-connected disability years ago, verbiage from CFR 38 changed, possibly increased the rating. Do you file a new claim, an appeal, or an increase for said disability? So what form do you file?
Wait, say that again now.
He was rated for a service-connected disability years ago, and verbiage in the CFR 38 changed, possibly increased the rating. Do you file a new claim, an appeal, or for an increased rating? And I would think it would be an increased rating, but it would be a 526 because it looks like it's been more than a year ago.
Yeah. You couldn't do an appeal. It is technically a new claim, but it's a new claim for an increased rating. And yeah, Carol's right. It's 526.
Okay, move it down. Yes, and this is another suggestion. If you felt you had an inadequate compensation and pension exam, call the VA and let them know. Remember, if you call the 1-800 number for the VA, you ask to speak for the VA, the section that schedules the C&P exams, because those are the people that send them out to these three companies, QTC, VES, and LHI. And if you're having a problem with one of these companies, you don't want to call the company back. You want to call the VA. And like this guy is saying, if you felt the exam was inadequate, or a lot of times what I have is I'll have clients where the veteran is set up, they want you to drive 100 miles and you tell them I can't do that. And so then the VA, the LHI or QTC says, well, he failed to show. That's not true. But you don't call those people back. You call the VA and let them know. And that's what I do in this case if you think it was an inadequate exam.
Okay. Carol, I had one last week where the vet was homeless, living in a tent in the Arizona wilderness. And they wanted him to come to Las Vegas for all of his VA exams.
I know, unbelievable.
He had no way to get, across town, much less to Vegas.
I know.
It's like, what are you? And then the contractor said, well, we're just going to mark you for not showing up. Like,
and I'm going to ask that you never use this contractor again.
Yeah.
And but we have to get the vet to do it because they won't talk to us. So the vet needs to call and say, look, this is what the person said. They obviously don't have a doctor near me. And so they want me to do something I can't do. And the VA will help you. They'll make sure that you get somebody that can schedule a doctor near you. Alejandro Vasquez, I did what you advised me of uploading a picture of my foot after my C&P examiner didn't fill the right DBQ and didn't look at my foot at all at the exam. Hopefully they'll take the picture in consideration. I have a veteran that had skin cancer, and the VA gave him a very low rating for the scars. And basically all I had him do was take a picture of his face, send it in, and he immediately got an 80%. So the best thing you can do for something like a scar or something that is apparent when you look at it is take good pictures and send them into the VA. But what you want to do is you want to make sure you identify these pictures. There's a form called 21-4138, and you can put on that form, this is a picture of me face on. This is a picture of me from the side. This is a picture of me from the left side, and the date. And then send that in. And that's really going to help your claim a lot more. Scars, it's really how they look. If it's puffed and red, that would show in the picture. And this is the way you win scar claims. This is Sergio Alvarez. I have 3 head trauma incidents noted in my service record. They state concussion and slow and deliberate movement. Is this an easy TBI claim? If so, how do I go about it? Kerry?
It sounds to me like one. I mean,
yeah, but we're dealing with the VA.
Yeah. Well, I mean, like anything, you need 3 things. You need the in-service incident, the diagnosis, and a nexus between the two. In your case, you've definitely got the in-service incident. If that's in your service records, they need to diagnose a TBI, which should be easier if you've had a concussion, right, to the point where you had slowed and deliberate movement. That, to me, spells neurological impediments, or some, maybe some serious neurocognitive issues going on there. But they're still going to have to say there's a TBI present. If the examiner comes out and says there's no TBI, even though that sounds counterintuitive, that's still them telling the VA there's no diagnosis. So that's what you got to look out for. But if they diagnose TBI on the exam, I would think for certain they would relate it to the concussion in service, I would hope. But yeah, file that claim.
File that claim. And then get into the VA and start complaining about the problems you have from TBI. Are you dizzy? Do you have a problem with vertigo? Are you having headaches? Are you having seizures? Are you having memory problems? You need to get in and let the VA know what's going on, because that's the first thing the examiner should look at is what's the VA saying about your condition. So if you don't have a diagnosis, like Kerry said, of TBI, you're going to have a problem. Now, here's another thing that I saw last week again. The examiner decided that, yes, my client had TBIs, but they had healed. They were gone. And so this clearly was something else. So it's important that you let them know the TBIs you had and the continuing problems you had from then until now. That's very important, okay? Do you file a new claim, an appeal, or an increase if the verbiage in the CFR symptoms has changed? That would be a 526 since it was over a year, right?
Well, I think what they're asking is, do you file let's see, do you file a claim or appeal just because the verbiage in the CFR has changed?
Well, this is the same person that had asked us before that he thought that they were giving higher ratings now. I'm sorry, I should have said that. So, but yes, and he said it was several years ago. So that's why I would say a 526.
Okay, I got you, yeah.
Okay, it's that time. The VA can see, pardon? The VA
well, I was going to say, make sure the new verbiage is actually favorable to you.
Exactly. It's that time. The VA concedes I was exposed to environmental hazards during military service. Is this enough for me to get service connection for hypertension under the PACT Act?
No, it depends on what those environmental hazards are and where you served and what you were exposed to. You know, if you're talking herbicide agents, yes, that's enough for you to get presumptive service connection. If we're talking burn pits, not necessarily.
You see, it was the first Gulf War. I see it down a little bit later. In the first Gulf War.
They didn't make hypertension presumptive, but that, you know, what they did make in the PACT Act is a concession of a lot of exposures. So that I think it enhanced the in-service event type of thing you need to show, because it's going to be harder for them to come out and say now, you know, you weren't exposed to anything. They pretty much can't go that route anymore, in my opinion, with the PACT Act. But it's not presumptive, so you still need a nexus when it comes to hypertension.
Right, and we have a lot of those claims pending. You know, just because the PACT Act has done certain things to give people benefits doesn't mean that we're not going to try for other things or for earlier effective dates on these. So if you think you should get those benefits, you need to file right away. Yeah. Mario, my healthy vet shows the VA received the opinion they requested, negative, of course, from the examiner 2 months ago. What could be holding up the decision? The VA is just really far behind, but when you see that, I'd go ahead and send a letter. It doesn't hurt to say, look, everything's in. Would you please make a decision on my claim? Joe Brawley, I was struck in the back of the head during service with a diagnosis of TBI, tinnitus, hearing loss, PTSD, memory loss, and neck arthritis with pain, and neck arthritis with pain from being struck, also hit face in pavement. There it is. Have had sinus surgery with chronic sinusitis. Could all this be linked? So let me go back. I was struck in the back of the head during service. I have a diagnosis for TBI, tinnitus, hearing loss, PTSD, memory loss, and neck arthritis with pain from being struck. Also hit my face on the pavement. Have had sinus surgery with chronic sinusitis. Could all this be linked?
Yeah, I think so. Doesn't mean it is. All right. Tinnitus, most people don't know this, but any longer, but tinnitus used to require either acoustic trauma or head injury. And I say acoustic trauma, just because you were around airplanes and stuff, you might not have had what you needed for tinnitus. But head trauma was one of the precipitating factors required for tinnitus, for service connection for tinnitus, a number of years ago. Same, you know, hearing loss is in that same boat. Obviously, a head injury can cause mental health problems. I wouldn't file for memory loss separate from PTSD. The memory loss most likely going to be a function of the PTSD. But like Carol always advises, I would claim entitlement to service connection for an acquired psychiatric disability to include PTSD, or not just the PTSD. The neck arthritis, you might have a little issue with that one, depending on how long it's been. But if you can show that the head injury was sufficient enough, then I mean that's a blow to the neck in a lot of different ways. Yeah, you could win that claim.
And then sinus surgery with chronic sinusitis. I think it could all be linked. And you know, the crazy thing is, you're sent for a series of C&P exams one day, and you have one examiner, and that person may be not very favorable. And then you happen to have the other sent for another day, and that person may be favorable. So you never know which of these things you're going to win. I mean, given the same day, you could win or not win depending on who the examiner is. So I would definitely file for all of these. Is there a link between PTSD and sleep apnea? Do you know, Kerry?
There appears to be. There depends on who you ask. If you ask,
I say yes.
Yeah, if you ask the VHA and certain universities, I think University of San Diego and a few others, they will say yes. There's evidence shows there's about, I don't remember the numbers off the top of my head, like a 60+% association with combat vets with PTSD and those with sleep apnea. It's counterintuitive to think, how does PTSD cause sleep apnea? But you know, we don't all know everything about the medical field, nor do the healthcare practitioners. But when you see such a high prevalence of an association from two conditions, it is not a coincidence.
Right.
But who thinks it is? All of VHA's, all of VA's contract examiners.
Exactly.
I don't know how many times we put that research right in their face, and they act like it just doesn't exist. And they all speak with uniformity on the issue. So, and they never speak with uniformity. You just heard Carol say you're going to get something out of one examiner, something else out of a different. Unless you file for PTSD and sleep apnea together, you're probably going to get the same thing.
Yep. Yep.
They're all in
But you can win that. You just have to get a good nexus, good opinion. We have a great pulmonary doctor who helps us, and then take it to the board, because that's where you're going to get it. Here's a good one. I have a pre-existing condition of flat feet that was documented in my exam when he went into the service. I was given supports for boots while in service. How do I prove aggravation?
You know, that can be a tough one in something like that. If it was definitely noted on enlistment, then you do not get the presumption of soundness. And with that, you do not get the type of presumption of aggravation that where the ball is in VA's hands to show it was not aggravated. It's in your hands to show it was aggravated. That's the difference. You're probably not going to see that difference without, you know, being very familiar with these kinds of cases. Technically, the law says if the condition worsened during service, it forces the question of, was that worsening a natural progress of the disease or caused by service? So when you've got something that pre-existed and it's noted on enlistment and it's there's no doubt about it, you can't escape it, and you get some kind of treatment for it in service, say, like you say, the boots, is that evidence of it worsening? It might be. There's no good answer to that. Obviously, if you had to go in and get surgery and your feet are never the same again, sometimes you can just, obviously it's a worsening of a condition. But that's the first question that needs to be answered: did the condition worsen during military service? Because if it was the same stage when you got out that when you went in, the examiner can just say, no, it didn't get worse. That shoots the claim down right there. If they say it did get worse, then they have to answer the question: is that worsening a natural result of the natural progress of the disease, or is it a cause of service? Flat feet, if you were there in the time where you couldn't wear the high-tech boots and you had the old flat bottom combat boots, or like I used to have to wear every day, the flight boots, or even worse. Yeah, you can show aggravation. You might need a nexus, but it could be an uphill battle if everyone's conclusion is it did not get worse during service. They were just treating you for the condition you had when you came in. So I probably didn't answer the question very good there in a short way, but so maybe.
Yeah, maybe. And this to me is where witness statements really help. If you can get somebody to really talk about how your feet got so much worse during service and you complained and you limped and you couldn't do things and you stopped playing whatever you were doing sports before, that's where I would really use the witness statement. So once again, that's not going to help you at the regional office. It's going to help you at the board. So these are cases you can win, but they're harder cases. Yeah. Steve Bennett. I filed for tinnitus in 1993 along with other items. They closed out the other three, assigning a 0% for one of them, but they never gave me the result for tinnitus. What should I do with the tinnitus claim? I love these. They're open claims. So but in order to get them to act, now here's the question. Do I send them a 526 or an 0995 for tinnitus? They've never made a decision. So I would just pick one, because whatever you pick, they may look on the code sheet and they may not look on the code sheet. So I would file one. If you don't get anywhere with that, I file the other. And then when they give you an effective date, that's when you say that this is an open claim and I want to go back to when I originally filed.
Can I add to that, Carol?
Please do.
So we've had, since the AMA, it seemed like somebody flipped a switch when the AMA was passed and everyone went to dumb on certain things. And a good example are motions for revision based on clear and unmistakable error. The M21, which is VA's internal manual, all their internal policies, procedures, they'll say it's not policy. We all know it is. It says there's no form to file a CUE. Okay. Now I'm saying that because the same thing exists for, as Carol's pointing out here, it's a pending claim. So let's say the facts are just like you say, and they might be different. I don't take offense to that. VA might have sent out a letter that no one ever received, and they may have disposed of the issue. But let's just say you filed for it. Truly, there was never a decision on it, and it's never been addressed since then. What you have is a missed issue, but to raise a missed issue, there is no form.
Right.
And so just like with the CUEs, and I've had to fight these issues in ways you wouldn't believe if you were familiar with this process, just to get the regional office to address it. Okay, they just thought, oh, we don't have to address that. It wasn't an appeal, or it wasn't a claim, or it wasn't, get lost, Baker. You have to address this if I'm raising it. So if you raise the fact that they missed it, all right, they're going to end up addressing it. How do you get them to make sure they address it? So we started with CUEs. It was the same thing. We'd file a CUE. There's no form for it. VA is now trained to look for forms. If there's no form, there's no claim. Yet they admit there's no form for this. And then they reject the claim for CUE because there's no form for it.
They ignore it, Kerry. They totally ignore it. They ignore it.
Or they ignore it. And we put on there on all of the ones that I do, I put, like an administrative note, big bold letters, there's no form for CUE. Don't cite them the section of the M21. Don't reject this because there's no form, because there is no form, and your own manual says so. But then we'll usually put it on like a supplemental claim. Yeah. So that, because this took some trial and error. And first we started putting them on 526s and supplemental claims. And inevitably you get a rejection letter saying, this is not the right form. Exactly. When there is no form. So the same thing applies here when you're talking about a missed claim. Okay. So how do you get around it? We put things in bold and try to get their attention, but ultimately we kind of resorted to putting stuff on a supplemental claim form, along with a memo explaining what we're wanting, explaining that there is no form. The supplemental claim form is just there to force them to look at the issue.
Right.
That's it. Because you don't need the supplemental claim form. You could do the same thing or with a 526, because neither one is right.
Right.
Is wrong. You're just trying to get them to recognize it. And I'm telling you, that is hard to do these days.
It really is. So I'm with you, Kerry, but that's why we file either a 526 or an 0995, and they have to respond to that. And if they tell you it's wrong form, then just file the other one that you didn't file. But you can't just write a letter explaining exactly what they didn't do because they don't pay any attention to it. It's like Kerry said, they're form driven. If you don't send them a form, they don't pay any attention to it.
If you have an inroad to them, you can get around that. And we do that all the time because we have the inroads, but a lot of people don't.
Right.
You know, so if I know how to contact a service center manager and say, look, 3 months ago, I filed this, it's a CUE, there's no form for it. Your office didn't make it a pending claim and put it under electronic control, or your office rejected it because there's no form. I can ensure that they pull their head out of where and get the claim established. Unfortunately, folks out there doing this on their own, you're not going to be able to do that.
No.
And it's not me trying to say you got to come to us with that. It's just a fact. So that's a problem in VA that they need to fix.
I know, and they have it. And so, it's like, do I want the claim to move on or I don't want to be right? And so what I do is I send them an 0995 or a 526 and they move it fine. If they don't, I send them the other claim. And they have to respond to that. Sam McGuire, if I listed migraines on separation exam, can I use that as a nexus?
You listed migraines
on a separation exam, can I use that as a nexus?
Well, you can use it to help win the claim. It's not technically a nexus, but if they concede that you had migraines while in service, migraines falls under 3.309A, you shouldn't need a nexus in that scenario. It should be a condition that was diagnosed during active duty that's also entitled to the presumption within 1 year.
Right.
You should not need a nexus in that scenario. But if you end up needing one, then I think you've got a much, much better chance of getting a favorable one with it on your exit exam. Yeah.
Right. Michael LeMay, can you file radiculopathy and degenerative disc disease at the same time? They're really the same claim. And that's one of the things that drives me crazy with the VA. They'll service connect the back and give them a rating for the back and not mention radiculopathy, even though it's clear that you have that. So I do think it's helpful to mention back and radiculopathy when you file the claim, because otherwise you're going to have to file an appeal, I'm finding. How about you, Kerry?
No, I agree. I agree. And I'd expand on that and say that goes for any kind of claim where a lot of the residuals of it are rated on that basis, on the basis of the residuals under a separate diagnostic code. Diabetes is a good one. Claim all the residuals right up front when you file that claim. Because today's VA, there's, I would say 50-50, but it's more like 75-25 chance that they're going to screw it up and not address the residuals if you don't put it on there. They are still supposed to. The issues within the scope of the claim under 3.155 D2, I think. So they are supposed to, but that doesn't mean they will. So
right.
Put all the residuals on the claim.
Including chronic kidney disease, which is one thing people leave off all the time. I'm not sure if I have this right, Arthur Taylor. Let me read the whole question. I was awarded 100% PTSD on May of this year. My PTSD was 70% as of May of this year. Sleep apnea secondary to PTSD as of July of this year. I initially filed for sleep apnea in 2005 after my sleep study and a CPA was issued, and I was denied. With help around April of 2022, we filed again for sleep apnea. It was kicked back with the file in the wrong form. I needed to do an appeal do I need to do an appeal or higher level review? I did an appeal and was awarded sleep apnea for April of 2022. Should have been backdated from 2005.
That depends. If you filed a claim in 2005 and they denied it and you didn't come back and do anything with VA until 2022, unless there's an error somehow in that original claim or something that leaves it still pending, if they, the question I would ask is, did they take the current rating back to the current claim. So it's 2022, whatever date you said, Carol, is that when you filed to reopen the claim, or had you been
Yes.
trying for a couple of years?
No, he went back to, it was back to April.
Okay, and
That's
if you
fine.
hadn't done anything since 2005, and there's nothing wrong with that 2005 decision, then no, they don't necessarily have to go back that far. If you have a claim that's denied, and you could debate whether the reason they denied it are right or wrong. Some things deserve an appeal that are wrong, but they don't rise to the level of an error that is effective date triggering, like a clear and unmistakable error. You know, I could look at a lot of decisions and say I would appeal that. But if I'm looking at the same decision 20 years later, that doesn't mean I'm going to say that's a clear and unmistakable error. I'm going to say somebody should have appealed that.
Right.
If you're into that category and you didn't appeal it, then odds are the current effective date is correct. You know, so you're asking the right question. Don't have all the info that really need to answer it, but at the same time, I just reading between the lines. You know, it may be correct if nothing else happened between then and now, and the first decision was not somehow the product of an error. What do you
And this
agree
is why we tell people, file an appeal. The worst advice you can get is just keep filing the same claim over and over again. Or you're told, wait a year and then file the same claim over and over again. Please don't do that. If you're entitled to it, appeal the claim, or otherwise you're going to lose all these benefits. It's really depressing to see something we could have helped if we had it at the time, but we can do nothing right now.
Yeah,
John,
I think there's a question coming up on Fort McClellan somewhere that
yeah, oh yeah, it was. Where did that go? You want to answer
BSO refusing to file a claim. I thought I saw it. I know I saw it earlier. I remember
I know this, my tracker keeps jumping back and forth, so see if I can see it.
I saw it just a second ago. Yeah, it may have disappeared off the screen.
I know. Here it is. My question is, Fort McClellan Registry reduced to an can't say that study. What can a veteran do if exposed to herbicides while at Fort McClellan?
Yeah, that's not the one I saw.
Me either.
That might be the same person though. Bear with us, everyone. We'll get it. I'm sorry, Carol. I didn't mean to get you off track there.
No, I couldn't find it either. I have been, and this is another bite. I have a claim that's been gathering evidence for 9 months. It includes colon cancer for being an arachno 3. How can I get them to get this done? Thank you. I think you need to send them a letter and ask them to work on it. This is one you may want to ask your congressman to help you to get them to move it along. If you have one of the things that causes them to expedite at the regional office, if you're over 85, if you have a Purple Heart, if you're a POW, if you've been evicted, foreclosed, utilities turned off, any of those things, let them know. And there is a form now that you need to use if you want to have it expedited. And I don't know the name of that form, but that's the form you need to file. We file a letter explaining what's going on and then attach the form because it only lets you check something like Purple Heart, financial, whatever. But other than that, I think the Congress people are the best to help you get this moving. Did you find that question, Kerry?
No, I'm thinking it might be the same person that, and the question is somehow hidden now because I went back to where you were before and I'm pretty sure we didn't miss it. I'm wondering if
I don't see it either. Okay, let's try this one. Kerman Wingfield. If you have a condition you are already rated at 10% for, now that it's on presumptive list, just recently passed, can you file for it to be increased? You want to talk about the difference in?
Yeah, that's not going to make a difference. If you're already service connected for something that they've added as a presumptive, that's not going to help you get an increased rating on it. You're entitled to ask for an increased rating at any time. Just because they made it presumptive that you've got service connection and you've got what they're going to rate your service connected disability. Sometimes they're just completely separated. But no, you can still ask for an increased rating. If you're only at 10%, odds are you probably don't have anything to lose. So you might as well go ahead. I'm sorry, there's a fly in my face. Might as well go ahead and ask for it. Yeah, Carol, what I had saw in that other question I wanted to address is not necessarily the Fort McClellan issue, but his VSO had told him they wouldn't file the claim. I think is how he, they wouldn't do it or told him he couldn't do it. That's wrong. I want everyone to know that. If you go to a VSO, do not let somebody tell you can't file a claim or tell you not to file a claim. I say that I would like to think if I told somebody not to file a claim, I'm giving them the right advice. So let me preface that. But I'm sorry if a VSO tells you not to file a Fort McClellan claim, because go the other way, go find someone else, because that's not the right advice.
Find another VSO.
Yeah, they're hard claims. There's no doubt about it. And we handle them and we fight them tooth and nail. Because we're after that issue, and it just one vet may have the case that breaks the dam open for everybody else. So don't let a VSO tell you not to file a claim.
And think about all of these people that tried to file for heart disease for Agent Orange back years ago, and they were told you're not going to win it, don't file it. That's wrong. If you think that you are entitled, file it. If you don't win, at least you've established it. And if years later you can prove that, then you have a claim. But not filing one, you have no claim. Yeah,
who would have thought, VA would go back 20, 30 years on certain herbicide-related claims?
Right.
Because of NEMR, they do that, but you would have never guessed that. So anyway, go ahead, Carol.
Sylvester Atkins. Hello, I'm 100% permanent and total, including bilateral 50% for feet. I developed drop foot. Should I apply for SMC? You should have a 60% for drop foot alone, right?
40 for drop foot.
Good. Okay.
Yeah. If 40 for loss of use of a leg below the knee, so that would be a foot. I would say is that one feet or both feet?
It says bilateral, including bilateral 50% for feet. I developed drop foot.
So if you got one drop foot, and we're talking legitimate drop foot, all right.
Drop foot is when your foot, when you go to walk, your foot doesn't pick up and go, you drag it a little bit.
And here's there's something that concerns me with the question. Flat feet typically, unless something's really severe, would not result in drop foot. Drop foot is usually the result of a paralysis of a nerve going to the foot that allows it, once it's paralyzed, it allows your foot to dangle. And you normally don't see that cause from a flat foot condition. I'm not saying it can't be. I'm sure it could be, but that's the first thing that would concern me. Well, let's just say that's not a concern, and the drop foot is definitely caused by the flat feet. My question still is it 1 foot, or both feet? Because the difference is significant. If it's 1 foot, you're going to get an SMCK, and it's going to increase your rating by about $150 a month. And it's going to expose you. Could they do something crazy and reduce your benefits? Just something to think about it, because you're already 100%. That's all I'm saying. If it's definitely both feet, that's going to get you SMCL, and that's definitely more than $150 a month. That's probably an extra $1,000 a month on top of the 100%. So then it becomes more worth it. Right. All right, to do that. And that would be my advice to something like that.
And we don't know what makes up that 100%, Right. That's very important. That helps you figure out how you balance, what do you appeal, what could you possibly lose if you appeal a certain thing. So all of this is, unless you know all the facts, it's really hard to give a good opinion here. Jackson Workshop. My wife is service connected for migraines at 0%. If I filed supplemental claims of statements from both of us stating she cannot have full-time employing, showing missed work, Does this show enough new evidence? It clearly looks like you need a higher rating for this. And so I would definitely appeal for a higher rating. And I think that statements from the veterans and from witnesses are very important. But remember the way they rate it. 10% is if you have at least one a month. If you want 30%, you need to show that you have a prostrating. That means you have to lie down, recliner, lazy boy. But to get 50%, you have to show that it interferes with your work. And you need to show how that is done. Can you not concentrate? Do you need to be in a dark room? How long do you have to lie down? How often do you have these? So you need to be very specific. But there are basically 3 questions on this large form that control the whole rating. And I've seen examiners say, I really want to help you. And they go on to how bad the pain is, how often you have the pain. But if they don't check those 3 boxes, that you have to, you're prostrating and it interferes with work, you're not going to get a higher rating. So look at that DBQ form and then make sure you include everything that's important in your statements. And if you can get your doctor to fill out that form, that helps you even more. But yes, I definitely file a claim. Is it a supplemental claim? That's the question. You want a higher rating. Has it been more than a year? Yeah. Then you file a 526. If it's within a year, you probably want to file an appeal, I would think. Wouldn't you, Kerry?
Yeah. And I have a bone to pick with the migraine ratings.
I do too.
So one says prostrating. All right. Well, they all say kind of prostrating. And the 50% says completely prostrating. That's like saying dead or more dead, or pregnant or more pregnant. Inability to rise is what prostrating is. And you're either on your back, flat out, laid out, or you're not. And so it's not completely prostrating. No, prostrating is complete. It's inherent to the definition of the word. And so I'm including that with my migraine arguments.
Remember that what's sad, Kerry, is I think a lot of people don't understand what prostrating means. And so, and then they don't think about it. If you're laying back in a recliner, you're prostrating. You have to lay back. Okay.
Yeah.
And then the other thing is about unemployability. The thing about veterans is the highest rating you can get for migraines is 50%, but that doesn't qualify you for consideration for unemployability.
Right.
So what you need to say is, I am not working. I want to be considered for unemployability. I'd send in an 8940, and then these cases have to be sent to the central office. And these are cases where we find these that we can reopen sometimes from years ago, saying that they should have considered this and sent this to the regional office. So remember, you're only going to get a 50% rating in most, but that doesn't mean you're not qualified for unemployability.
Mm-hmm.
Okay, Cecil Dixon, I made a secondary claim for my plantar fasciitis due to ankle injury, which wasn't rated at the time, but denied. I want to make a secondary for my same heels due to knee injury I was rated for. Oh, where does the rest of this go? Cecil Dixon. I'm looking to pick up the rest of that, and I'm not seeing that. Sorry, Cecil. That's all I can see right there. You see that, Kerry?
I see the Cecil Dixon question, but I see it stopping where you stopped.
Yeah, okay. Maybe we'll run into it later. Can 100% permanent total veteran get Social Security disability if they haven't worked 35 years? Or would such a veteran only be eligible for SSI? In order to get Social Security disability, you have to work and pay Social Security taxes for half of they take a 10-year period from when you stop. When you want to get disability, they go back 10 years and you have to pay earnings credit for half of that time. So you have to work and made enough to get the 4 quarters. You can get 4 quarters of credit each year. So in a 10-year period, you could get 40 quarters and you have to have 20. So and they call that insured. So when they set up the Social Security system, it initially only had retirement. They added disability later, but they made this qualification. We don't want people who have not been working to get disability. So you have to have worked 5 out of the last 10 years. And the way you can make sure that's correct is you order your Social Security earnings record, or you can go online. You should be able to set up your own account and download it. And it will say on there, you are insured through whatever year. So if you didn't work in the last 35 years, I don't think you could get Social Security disability. Okay. Okay, let's go down just a couple more. I think we're through for the day. Oh, it says, my question is Fort McClellan Health Registry. No, that was when we started looking at it. I'm granted M&M motives. Greetings. Once granted TDIU 100%, can you still file other claims and still compensation and pension for other existing service-connected disabilities? Kerry?
Can you do that one again?
Okay, greetings. Once granted unemployability 100%, can you still file other claims and still compensation and pension for all other existing service-connected disabilities?
Ah, yes. Okay. Back to my pet peeve that I always warn everybody about. You can file all the claims in the world, but should you do it if you're 100%? And I don't, particularly if you're 100% based on unemployability, but it really doesn't matter. You're 100%. When did you start getting that 100%? Is it protected? What are you filing for? They're not going to just pay you extra compensation because you have an additional disability when you're already rated 100%. I'll give you an example. If you're rated 100% for PTSD and 60% for a heart condition, you're going to get SMCS, which is the housebound rate, because 100 plus 60 is housebound. So you're over the 100% rate. Okay. Well, let's just say you develop lung cancer that's the PACT Act would service connect. All right, and it's active, but otherwise you're okay. They're treating it and all that. You would be entitled to 100% rating with that lung cancer. It won't change your level of benefits. You'd have 200% ratings and a 60% rating. It will not change your level of benefits unless it forces you to need more aid and attendance, something that the SMC is not covering. Okay, so there's a lot of things you can do that are not going to affect the ultimate outcome of your claim, except put eyes on it by VA employees who could do something detrimental. Now, most of them aren't looking to do something detrimental, but man, they can do something detrimental out of incompetence or ignorance. And so you gotta ask yourself, if it's not protected and if it's not going to change your level of benefits and change your life somehow, my advice is don't do it. If it's not going to have an effect, except for getting people to look at your case. Now, if you're protected, if you've had that rating for 20 years or more, that's a different story. They can't take your benefits then. If you've got something so static, there's no chance of a reduction, like an amputation, like loss of use of an extremity. Those are usually, just static, and they're not going to change. If that's what the 100% is based on, then I think you're safe there too. But otherwise, be careful. That just goes for everyone. If you're 100%, be careful. Don't think you're going to get extra benefits because they add tinnitus to your claim when you're already at 100%. It's not going to change anything. Don't try to request an increased rating in your psych disability when it's rated 100%. Or even if I'm getting TDIU for it, leave it alone. Because nothing, all bad can come from it. So anyway, I just feel that's important. I see a lot of vets that do things that they think they're going to help themselves, and they end up, oh my God, I've got a reduction on my hands, and now they're really having panic attacks. And just be careful. If you're not sure about that, ask somebody with some experience. And that usually is not people online on Facebook. it might be, just be careful.
I know I hear crazy things from my veterans that they tell me that's the law. I think, no, it's not the law. But another thing is people, like if you have 100%, the VA is covering all of your problems. So you don't need to file service connected for hearing. You can get hearing aids. You don't need, if you have a dental problem that you think was caused by the military, you don't need to file. You're covered. Yeah. And that's what, you need to think through. How is this going to help me and how could it possibly hurt me? Okay. Well, Kerry, it was fun. Another week with you.
Yeah, so. I liked it. Enjoyed it. I'm always like doing these things with you, Carol, because they're just pleasant as can be.
Well, I have to try to be more aggressive and nasty next time.
Okay,
everybody have a good week. It was great to be with you this week. And we're going to post that form that shows how to expedite your case. We'll post that online for you so that you can see what it is, because I don't remember the number of it right now. Have a great week. Bye.